everyone, and welcome. My name is Leah, and I'm the Knowledge Exchange Manager here at Women's Shelters Canada. And I'm moderating today's webinar. I'm super excited to host this conversation. I think it's going to be really interesting. Before I get into it, I want to start by acknowledging that I'm joining you today from the traditional unceded territories of the Algonquin and Anishinaabe people. And I also want to acknowledge my responsibility as a settler to continue to learn about the historical and present impacts of settler colonialism and to support the ongoing work of reconciliation and decolonization. And I know with this virtual setting, there are folks joining us from all across Turtle Island today, which is wonderful. So please do say hi in the chat. Feel free to introduce yourself, let us know where you're joining from, and we'd love to get a sense of who's in our virtual room today. So as I said, I'll just do a few quick housekeeping reminders here. Once again, with the interpretation, as I mentioned, we will be speaking in English today, so you don't need to turn on the interpretation if you're listening in English. If you would like to listen in French, pour celles qui veulent l'audio en français, veuillez cliquer sur le bouton Interprétation en dessous de votre écran et sélectionner French, Français pour l'audio en français. And my colleague Chandra, who's also here to help out with the chat, has posted those instructions in the chat if you would like. You have probably noticed that we do also have the captioning feature on today for those who are interested. If you don't want to see those captions, you can click on the CC button at the bottom of your screen, and you have the option to hide them or to turn them back on or to open up a transcript in the side of your screen. So do feel free to make that work for you. Now, you have probably noticed that only the presenters have their video and audio on today, and that's just to make sure we have great audio quality for everyone here. It doesn't mean we don't want your participation. We definitely do. And there's two ways you can do that. You can use the chat to say hi, like some of you are doing, or to make a comment, or if you have a tech question that you want Chandra or myself to help you with, feel free to put that in the chat. If you have a question for our presenter, please use the Q&A box for that. It's sort of right beside the chat box on your screen. And that just makes it easier for me to keep track of the questions and for us to get to as many questions as we can today. So please feel free to put questions in the Q&A throughout, and we'll address them as we go. And just a final note, we are recording today's webinar, and so we will be sharing the recording afterwards. So if you need to leave a little early, or if your colleagues couldn't join us, that will be available afterwards. Now, I'll jump in. So as you all know, today's webinar is about parenting challenges for women with abusive ex-partners. And today we're focusing specifically on managing the best interests of the child test. Now, as some of you probably know, this is part 2 of a 2-part series with Pam Cross, who is the legal director at Luke's Place in Ontario and a respected expert on violence against women and the law. Now, part 1 took place in October, and it was focused on the relocation of children, decision-making for kids. If you weren't there, if you didn't have a chance to join us, don't worry. We do have a recording, and so my colleague will put a link to that in the chat. It's also on our website, so if you want to watch it or you want to refresh your memory, you're welcome to do that. Now, before we jump in, I just am going to launch a quick poll here. We would love to learn a little more about all of you, so you should see it pop up on your screen. And we're just curious where you're joining us from, what your role is in the shelter, the transition house where you work. Are you frontline, legal support, manager, ED, that kind of thing? And thinking about the best interests of the child test, are you comfortable explaining it to the women you serve? Just so we have a sense of where everyone's at as we go into this. So I'll give you a couple seconds to go through and submit your answers. All right, it looks like most folks have participated, so I'm going to end the poll and share those results. So hopefully you can see it on your screen, but if you can't, we have lots of folks from BC, Alberta, Ontario, Quebec, and the Atlantic region. And so sorry to the folks from the Atlantic, I had a limited number of slots I could put in, so I apologize for grouping you all together. And we have lots of frontline staff, which is wonderful. Some folks under other. So if you want to let us know what your role is, feel free to do so in the chat. And a bit of a mix here with the best interests of the child test. So most folks kind of sitting in the somewhat comfortable range, but definitely a third who aren't very comfortable with it, and 24% who are very comfortable. So that's a great mix for us heading into today. So with that in mind, I will pass it over to Pam.
Thank you very much, Leah. I'm just going to share my screen with you now. Always takes me a minute. So everybody can see that screen. Fantastic. Okay, step one, success. I never have gotten comfortable with technology, I have to say. I'm really happy to be here with you today to talk about some of the parenting challenges for women who've left relationships in which they've been subjected to abuse. And then, as you all know, of course, that abuse continues even after the separation has taken place. Let me begin by acknowledging where I'm talking to you from. I'm in Kingston, which is the traditional territory of the Huron-Wendat, Anishinaabeg, and Haudenosaunee peoples, whose presence endures here. As Leah said, I'm the legal director with an organization in Ontario called Luke's Place. I want to tell you just briefly what we do so you understand the context and perspective of what I'm going to be talking about with you today. We provide direct services to women who live in Durham region, who've left abusive relationships, and who are engaged with the family law process. We do that bringing a team approach in which women work with their own legal support worker, as well as pro bono lawyers who offer their time to us. Our LSW, legal support worker concept, was the model on which the provincial government based its family court support worker program, a program that offers free family court support to survivors of family violence across Ontario. And I'll wager a bet that at least a few of you are madly writing away now your proposal to the Department of Justice, which has a call out right now offering funding to develop family court support worker type programs. Good luck to all of you, because we need this program right across the country. We also do work at the provincial and national levels where we conduct research, develop resources, provide training, and engage in systemic advocacy. You can see our 3 websites down the right-hand side of the slide. The general public website is lukesplace.ca, and you can find a lot of information there, or your clients can, about family violence and family law. On the bottom, lukesplacetraining.ca is where people who have registered for any of our several different training programs can access those courses. And on the top, familycourtandbeyond.ca, which I'll talk a little bit more at the end of today's presentation, because it's a really helpful resource on this very topic that we're discussing today. I'm a lawyer, so of course I have a disclaimer. This webinar is not legal advice. It should not be interpreted as that. Only a lawyer who's been retained can provide legal advice about a specific situation. I will, of course, use examples. They're general examples, and you can't assume that if you are working with a woman whose situation is somewhat similar to an example that I give, that everything is going to be exactly the same as it is when I describe it to you. So really important to understand that what we're sharing today is information and not legal advice. The information is current and correct to this date, January 13th, 2022. So that's it for me in terms of talking like a real lawyer. I'm going to talk like a normal person now for the rest of the time that we're together. As Leah said, this is the second of 2 webinars about post-separation parenting challenges for women whose partners continue to be abusive and controlling even after the relationship has ended. In October, we looked at decision-making and what a woman needs to do if she wants to or needs to move with her kids. Today, we're going to look at the requirements that are set out in the best interests of the child test in the law including those that don't seem to really reflect the needs of women who have left an abusive partner. In doing so, I will, of course, look at the law, but I'm also going to refer to some court decisions that have been made since the revised Divorce Act came into effect in March 2021. And both Chandra and Leah are watching the Q&A for any questions. I'm going to stop a couple times to take a breath and see if there are any questions posted there. But also in the meantime, if a question comes up that you think needs to be addressed right away, just interrupt me and we'll stop and take it then. Before we dig right into this topic, I want to remind you all about how family law operates in Canada and give you a brief summary of the relevant revisions to the Divorce Act. Most family laws in Canada are provincial or territorial. The Divorce Act is the only legislation that applies to everybody in Canada. And it applies only to people who are legally married and who are seeking a divorce. All other people, so people who are in a common law relationship, two people who parent a child but have never even lived together, even people who are married if they're not looking for a divorce, must rely on the legislation in the province or territory where they live. Those laws are not always the same as the Divorce Act. And I'm sure you already know that, but just a little reminder here that if your job requires you to assist women with their family law issues, you should make sure that you're familiar with both the Divorce Act and the legislation in your province or territory. When people apply for a divorce, they can also ask the court to make orders related to various other matters. Arrangements for the kids, which used to be called custody and access, but is now called parenting time and decision-making responsibility. They can also ask the court to make an order for child support and spousal support, as well as for an order dividing up the property that the family has. If the people are not married or if they're not seeking a divorce, they're using provincial or territorial laws through which they can get everything I just said. But in addition, provincial and territorial legislation govern some safety issues through things like protection or restraining orders and orders for exclusive possession of the matrimonial home. Family laws historically have been largely silent on the issue of family violence in this country. However, the revised Divorce Act and some provincial family law statutes, most notably Ontario, Alberta, and British Columbia, and I may be missing some, but those are the kind of big three, now contain a definition of family violence that is broad and inclusive. And I'm just going to take a minute to read this to you. The bold faces are mine. They're not in the actual law. And this is the language taken out of the Divorce Act. Family violence there, and the wording in the provincial statutes that have it is virtually identical. The definition says that family violence is any conduct, whether or not that conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes the other family member to fear for their own safety or for the safety of another person. And in the case of a child, the direct or indirect exposure to such conduct. So you can see that we now have a very broad and inclusive definition of what family violence means. The definition goes farther, though. It moves on to define specific kinds of abuse that are considered to be family violence. Physical and sexual abuse, threats to kill or cause bodily harm to any person, harassment, including stalking, the failure to provide the necessaries of life, psychological abuse, financial abuse, threats to kill or harm an animal or damage property, and the killing or harming of an animal or the damaging of property. It's important to keep this definition in mind as we now move on to look at the best interests of the child test, and where it's helpful and sometimes not so helpful to women who are fleeing abuse. Are there any questions at this point just about the structure of the law?
There aren't any questions yet, no.
Okay, great. So let's have a look at the best interests of the child test. And as I said to Leah before, I seem to have an ongoing problem advancing slides when I'm using Zoom, and I apologize for that. But I hope you can just put up with a little bit of confusion that seems to arise from time to time. The best interests of the child test is the test, if you want to call it that all courts must use, whatever part of Canada you live in, when they're making any decisions that are related to children. Courts must focus on what's best for the children, as opposed to considering so-called rights or interests of either parent. There's a lot of talk about, I have the right to spend time with my child. In Canada, there isn't actually a legal right for a parent at all with respect to their children. In other words, a parent does not automatically have a right to spend time with their child. Of course, most often they do, but that decision, if it has to be made by a court, if the parents don't figure it out on their own, is based on what's in the child's best interests, not on some concept of a legal right of the parent. Very different in the United States. So if you watch American television, you'll hear conversations about the parental rights. That concept doesn't exist in Canadian law. Everything is focused on and surrounded by this concept of what's best for the child. Now, having said that, I'm going to tell you, and you know this if you've ever assisted a woman in family court, that court decisions often sound as though the parent has rights, especially in cases involving family violence, when the mother wants to restrict the father's time with the kids because she's concerned about their safety. And we hear all of this talk from the father and the father's lawyer, and unfortunately sometimes from judges as well, about the right of the father to spend time with the children. It's not actually a legal right. The Divorce Act and most provincial and territorial legislation provide criteria for courts to use when they're considering the best interests of children. It's a list of factors, and we're going to look at each one of those in just a minute. But what I want to say before we dive into that is that there's no weight attached to each criterion. So this thing is called a test. It's really a list. It's not a test. And it's not as though it says, okay, the first factor that the courts have to consider is worth 10 points, and the second one is worth 5, and the next one is worth 20. They're just all listed there. And the judge, the court, has to look at all of them together, coupled with the facts of the particular family, to determine which of those factors or criteria are the most relevant. And you'll see as we look at them that it's pretty easy sometimes to determine that a particular factor isn't that relevant in this specific family. Now, what that also means is that there's a lot of judicial discretion. The judge is going to be bringing their own bias, their own perspective, their own knowledge or lack of knowledge as they are assessing each of those factors. Sometimes that's a good thing, sometimes it's not. And when we look at a couple of cases in a few minutes, you'll see some of both of those kinds of decisions. There are 11 factors in the best interest of the child test that's contained in the Divorce Act. So we're going to look at those first, and then I'm going to focus on the two that I think are potentially the most challenging for women who are leaving an abusive partner. First in the list is a requirement for the court to consider the child's needs, taking into account the child's age and stage of development, as well as the child's need for stability. Next, the court must look at the nature and strength of the child's relationship with each spouse or parent, their siblings, grandparents, and anyone else who plays an important role in the child's life. Now, that anyone else is a pretty narrow category as it's interpreted by the courts. It's not going to be the daycare worker, even if the child is in daycare most of the time. We're really looking at the family and extended family when we're looking at this criterion. So these are not surprising factors. courts are very much focused on stability for children. And the attitude seems to be, and I think it's probably correct, that the child is already going through a considerable upheaval simply because the parents are separating. They're not all going to be living in the same house or apartment together anymore. And the court wants to minimize further disruptions to their lives. So they want to look at, what does this child need so that their life is as stable as possible? And what kinds of relationships does the child have with those people in the immediate and more extended family? That can, of course, include the father, even if he's been abusive to their mother, and in some cases, even if he's been abusive to the children. So while family violence is something the court looks at, it also looks at the child's relationship, and the child might have quite a positive relationship with the father. And so this can become challenging. So those are the first two criteria: the child's needs and the child's relationship with people in the family. Next, the court looks at the willingness of each parent to support the child's relationship with the other parent. This is one of the two that I flagged is very challenging for women who have left an abusive relationship. And I'm going to come back and talk about it in greater detail later. But there it is. It's number 3 on the list of 11 factors. Again, not surprisingly, the court looks at the history of care of the child or the children. Has one parent historically provided most of the care, or has this responsibility been shared more or less equally between the parents? The court also wants to know what the child's views and preferences are. Now, this is a really good example of how the court will give different weight to specific factors depending on the facts. If the child is an infant, this factor is going to carry very little weight. It doesn't carry no weight because it could be that a social worker works with the family and submits a report to the court, even with an infant, and says, you know, the mother and father are both in the room. The baby is crying. It leans towards the mother. It reaches out for the mother, or it reaches for the father. But the child really isn't in a position to express their views or preferences. On the other hand, if the child is, say, 12 or 13, their views or preferences will be given considerable weight. Now, just to make sure everybody knows this, if this is all new to you, children don't come in the courtroom and go in the witness box and in front of both of their parents say, I don't want to live with dad, or I don't want to live with mom. Information about the children's views and preferences is gathered differently in different provinces. In Ontario, we have something called the Office of the Children's Lawyer, which can appoint either a lawyer or a social worker to talk to the kids and get their evidence. It's also possible to go through a private assessment and that kind of thing. But that is a significant factor out of the list of 11. Next, the court looks at the cultural, linguistic, religious, and spiritual upbringing and heritage of the child, including Indigenous upbringing and heritage. Another example, if the family has no particular engagement with a spiritual or religious community or belief system, then this factor is going to carry a little weight. However, if the family has traditionally participated in a particular religion or practiced a specific form of spirituality, then the court will consider what arrangement will best preserve that history. Where the parents disagree, and it happens a lot, this can become a difficult issue for the court to resolve. I mean, it could even be that the family didn't practice any particular religion, and then post-separation, one parent becomes very immersed in a religion and wants the children to become very involved with that as well. The other parent objects. The court is going to have to figure out what is best for the children, not what's best for the parent, but what's best for the children. Next, the court must consider what each parent's plans for the child's care are. This can be very frustrating for a woman, especially if her partner was previously relatively uninvolved with the kids, but now shows up in court with a detailed and ambitious parenting plan, claiming he's now ready to be the father he never was before. And there are a lot of fathers who do this. I would say in particular, men who have been abusive to their partner. I'm sure you're all familiar with this pattern of behavior. It's not that they've suddenly decided they want to be dad of the year. It's because they know that this is the mother's most vulnerable spot, the children. And so he's going to come into court and say, we should share the parenting, or I should have the kids with me most of the time. Here's my plan for the future. He doesn't really mean any of it. He's not going to be a particularly great father. But it's a way of sending a message to her that just because you've left me doesn't mean that you're actually getting out of my circle of power, if I can put it that way. So when we think about this factor, plans for this child's care, it's also important to remember the one we talked about just a minute ago, the history of the child's care. If the mother has been the primary parent throughout the relationship, her evidence to support this will help offset any claim the father makes about his plans for the future. And so it's important for women to provide these details to the court. We have 2 children, they're 6 and 10 years old. I stayed at home until the youngest child was in school full time. I'm the one who makes their lunches, sits at the kitchen table with them while they're doing schooling from home, or sit at the kitchen table with them while they're doing their homework. It's my phone number that the school has if there's an emergency. I'm the one who gets them to doctor's appointments, dentist appointments, makes sure they get to birthday parties, and so on and so forth. So then when the abusive ex shows up in court and says, but I have a plan for the future, the mother can say, yeah, I have a plan for the future too. And it's very much like the plan from the past. And that's what's going to give the children the most stability. So we come back to that word stability. In family law, history is the best predictor of the future. So a parent who's really not been involved in the past can make all the promises they want, but the court should not be ignoring the other criterion that it has to look at what's the past history of care for the child. Now we move on to some more criteria that can be challenging in the context of family violence. The court looks at the ability and willingness of each parent to care for and meet the needs of the child, which also requires a consideration of past arrangements. If I've never done anything with the kids before, how can I convince the court that I actually have the ability to do it in the future? Have I ever changed a diaper? Have I gotten up in the night with a sick child? Do I know how to take a kid's temperature when they feel feverish? All of that. The court then looks at the ability and willingness of each parent to communicate and cooperate with the other on matters relating to the children. This is the second one that I'm going to come back to in just a minute, because it too, as I'm sure I hardly have to explain to anybody here, is very problematic for women who have left an abusive relationship. Perhaps most importantly, for the women we support, the court is now required to consider any family violence and the impact that it has on both the ability and willingness of the abuser to care for and meet the needs of the child, and the appropriateness of requiring the survivor to cooperate with the abuser. So you see how this factor, which is the second last one in the list, it's number 10 of 11, the order doesn't matter, now starts to sort of push back against some of those earlier factors. Let's say I'm the abusive spouse and I say, yes, I'm able and willing to take care of the children, and I'm very happy to cooperate with my partner. Then if my former partner has a good lawyer, that lawyer is going to be able to say, I've got some evidence that might contradict that. Here's some evidence that shows that a man who abuses his partner is not necessarily the most appropriate person to have primary care of the children. So the court has to look at both of those issues in the context of family violence. If either person has raised the allegation of abuse, now the court thinks about, okay, so what's the possible impact of that family violence on the abuser's ability and willingness to care for and meet the child's needs, and on the appropriateness of an order that would require the survivor to cooperate with the abuser. Finally, the best interest test says that any civil or criminal proceeding, order, condition, or measure that is relevant to the safety, security, and well-being of a child is to be considered by the court when it makes a parenting decision. So while, as we saw when we looked at the definition of family violence a few minutes ago, it is considered family violence whether or not a criminal offense has been committed. If there have been criminal proceedings, the mother can bring that evidence into the family court case. If there's been a civil proceeding, if there's been a child protection case, if there's currently bail conditions, a restraining order, any other kind of order that speaks to the fact that there are safety concerns, then that becomes evidence for the court to consider as part of this list of 11 criteria that are connected with the best interests of the child. I see a question in the Q&A. Do you want to let us know what it is?
Sure. So it relates to the idea of kind of parental rights that you mentioned earlier.
Mhm.
So the person saying, you've said that the parents don't automatically have rights to spend time with their kids, but even so when there is domestic violence, often, the courts will say kind of, or well, people will say that the father has the right to see and spend time with the child, and courts encourage children to have a relationship with the father and the mother. So doesn't that kind of imply that there's a right to spend time with the kid? Yeah.
Well, it's a really good point that you're raising there. And I would, first of all, I don't like talking in a totally legalistic way, but it is important to understand the difference between what people say and what the law says or what the courts say. And courts are very careful. There are judges that talk about the importance of both parents playing a role in the children's lives. And I think most of us would agree that where that's safe and healthy for the child, that is good for kids. But they will always couch it, unless they're incredibly sloppy, as being what's in the best interest of the child. So you're not very often, and you should never, see an order from court that says, well, the father has the right to be with his child. What you'll see is, I've heard all this evidence about family violence. I believe it, I don't believe it, whatever. I have concerns about the mother's safety. However, I still believe it's in the best interest of the child to have a close relationship with the father. And so I'm going to make an order that says the father can be with the child, on the following schedule. I've also seen orders, not so many of them lately, and so I'm hoping this is changing, where the judge might say, for example, thinking of this list of criteria, the parents have a history of poor communication. Well, we would understand that not as a history of poor communication, but as a history of one parent, usually the father, being abusive to the other parent, right? And so, yes, the father doesn't communicate well. But anyway, the court will say something like that. There's a history of poor communication, but I believe it's in the best interest of the child for both parents to be closely involved in the raising of the child. And so my order is going to require the parents to consult and collaborate on major decisions relating to the kids. These are examples of bad decisions for the women that we support, of course, but they're not uncommon. Sure, people in the public, neighbors, friends, families, may well say, well, that's not fair. He's got the right to spend time with his child, but that doesn't mean it's a legal right. And courts, while it may seem as though they're talking about rights, will usually frame that as best interests of the child. I'm not saying the courts get it right. I think that far too often there are orders for what used to be called joint custody or joint decision-making, now called parenting arrangements and decision-making responsibilities. Far too often, courts are ignoring the problematic reality of those kind of orders when one parent, the father, has been abusive to the other parent. And that somewhere in that judge's mind is the notion that the father has a right or should have a right to spend time with the child. But that's not the language they generally use, because that's not what the law in Canada says. Now, I'm going to say one other thing about this, because it is complicated in a way. And this isn't really I didn't put it into the formal presentation because it's a little bit aside from the best interest test. When two parents separate, neither one of them has an automatic right, in quotation marks, to just take the child and move across town. Both parents are seen to be equally responsible. I like to change the language from right to responsibility. So both parents are equally responsible for those kids until there's an order from the court or an agreement between the parents about one parent having the child at this time and the other parent having the child at that time. So even when we look at it in that context, I think it makes more sense to think about parenting responsibilities. I don't know how many of you are parents. I am, although thankfully my kids are in their 40s now, so I don't have to do too much hands-on parenting. But most of the time that didn't feel like I had won a lottery or that I had some great big right. It mostly felt like a lot of responsibilities. And I think that for people who are really engaged and conscientious parents, they're not so much thinking about their rights as their responsibilities. So that was a really long comment on a really good comment, and I hope it was helpful. Anything else, Leah?
No, nothing else right now. Thanks, Pam.
So I want to go back to the two criteria that I said have the potential to create difficulties or challenges for women whose partners have been abusive to them. And we'll see if the slide will decide to advance. There we go. So first of all is the requirement that the court consider the willingness of each parent to support the child's relationship with the other parent. The abuser is going to say right off the bat, absolutely, oh yeah, no problem at all. The mother, on the other hand, may be a little more cautious because she has concerns about whether the child is safe when the child is with that other parent. Mothers have good reason to be anxious about their kids spending time with the father when he has been abusive to the mother. It's not uncommon for an abuser to respond to any limit the mother tries to set on the child's time with him by claiming she's engaging in parental alienation, and then we're off away to the races. It just becomes a nightmare. But it's not at all unreasonable for me to say, for example, he's never had anything to do with this child who is now 11 months old. He has never changed a diaper. He has never given the baby a bottle, has never gotten up in the middle of the night. I'm not against the child having some kind of relationship with the father, but what's really in the child's best interest here? It's not a week on, week off kind of arrangement. Or for me to say, my 10-year-old has been witnessing the abuse I've been subjected to for the past 7 years. Here are some examples of what has happened when the child's been in the room. I'm reluctant to just send this child off to spend vast amounts of time with this person. I have no idea how he will behave. Lots of women, and you all know this, engage in protective parenting of their kids, both while they're still with the abuser, so not leaving the kids alone with the abuser, and so on, and after they separate. And that can be, unfortunately, interpreted by the court, especially where the judge hasn't had enough education on family violence, as a lack of willingness to support the child's relationship with the other parent. So women are left in this impossible situation. If the woman limits the child's relationship with the abuser because of safety concerns, it looks like she's unwilling to support the child's relationship with the other parent. On the other hand, if she says, sure, whatever you like, is she taking the appropriate steps to ensure that the children are safe? This is where evidence is really important. Evidence is always important in family court. It's especially important in cases that involve family violence, because unfortunately, judges need to be better educated about the issue and need to understand all of the ramifications that are involved, need to really understand that while the child may never have been in the direct line of fire, perhaps never even in the room, that this does not mean the child hasn't been affected and does not mean there's no safety concerns for the child. One of the other things, of course, here as well is that, and the psychological research is increasingly showing this, child psychologists are saying, children's best interests can't be met if their primary caregiver is or feels unsafe. And so an arrangement that requires an ongoing, extremely close relationship doesn't ensure that the survivor of the violence both feels and is safe. And that leads us to the second challenging criterion, this requirement that people be able to communicate and cooperate with the other parent. Very, very difficult for a woman who has been living in a relationship where she's been abused. Many women are not willing, and many women are not able to communicate and cooperate with their former partner because of his past and ongoing abuse. She may be afraid of him, knowing that if she doesn't go along with whatever he wants, she places herself at risk of further abuse. She may, probably does, have a lack of autonomy and agency and be reluctant to make suggestions. Well, that's not a cooperative arrangement. That's not a communicative relationship. Then it becomes one in which the abuser says, I think the children should play soccer this summer, even though they've never played soccer before and they've always played softball. And the mother thinks, well, is it worth fighting with him about this? If I fight with him about this, what's going to happen down the road? Sure, I'll just go along with that. That's not real communication. It's certainly not collaboration, but it's very common for somebody who has been subjected to abuse and is now being told, you got to communicate with this guy. You got to cooperate with him when it comes to anything to do with the children. Now, the abuser comes into that situation from quite a different place. He's going to take advantage of this factor. So when he's submitting his evidence to the court, he's going to say, yes, I really want to communicate and cooperate with my ex-partner. I just want to do whatever's best for the children. He will argue that it's the woman who's being hard to get along with. Of course, he's not being honest. There's a surprise. And he will use the communication as a way to manipulate the woman. And any cooperation will really be him doing whatever he wants to do. He'll agree to one thing and do another. He'll claim the woman misunderstood him. He'll take a tiny little opening or vagueness in the court order and make it big enough to drive a giant truck through. Oh, well, I didn't understand when it said I had to bring the children home by dinner time, or bring the children back to you by dinner time, that you were going to have dinner at 6 o'clock. I don't eat dinner till 10 o'clock. So they're here, 9:30. I brought them home by dinner time. I'm sure you have many good examples of how problematic this requirement is in situations involving family violence. I encourage you to share them in the chat. I don't see any questions in the Q&A right now, but I'm going to take a deep breath before moving on to the next part of what I want to talk about, and just give you a chance to pop a quick question in there in case you have one. So we've looked at the general framework in family law, the general definition of family violence that now exists in the Divorce Act since March of last year. The list of the 11 best interests of the child factors. And in particular, I've honed in on the two that are or can be problematic for women who've left a partner who's been abusing them. The first one, of course, is the willingness of the mother to ensure a close relationship between the child and the other parent. And the second is the requirement that each parent be willing to communicate and cooperate with the other. What I want to do now is take a few minutes to look at some of the cases that we've seen since the changes to the Divorce Act. And I'll preface looking at the cases by making this general comment. The changes to the Divorce Act that came into effect in March of last year are huge. It is kind of a once in a lifetime experience for a lawyer to see a piece of legislation changed as much as the Divorce Act was changed. And so all of us who are lawyers or who work on in any kind of legal service for women leaving abuse have been keeping a very close eye on decisions right across the country. We want to see whether this change in the law, as it's written, is actually manifesting itself as changes in court decisions. There's a lot of factors involved here. First and foremost, all of the decisions that have been made since the changes to the Divorce Act, and in Ontario, the changes to the Children's Law Reform Act, have been made in the context of this pandemic, which just seems never to end. And so that's just a huge whole other layer of complexity and uncertainty that is affecting the kinds of parenting decisions that courts, that judges are making right now. So it's kind of a lousy time to be evaluating whether the changes to the law are showing up in court decisions. But until we know that lawyers have been really well educated about family violence, until we know that lawyers are routinely screening new clients to determine whether or not family violence is a factor, until judges have been properly educated about the changes to the law, we can expect that there will still be decisions that reflect the old thinking. The old thinking was family violence wasn't even mentioned in the Divorce Act. It wasn't a mandatory factor. There was no definition for it. There was very little legal recognition that family violence was even a thing. So bear that in mind as we look at these few cases that I have here for you. But Leah, is the question one that I should take now?
Yeah, it's sort of about the criteria you were talking about before. So maybe it would be good to finish with that before going into the cases. So the person is wondering if you could talk a bit about how shelter workers could advocate for women when the abuser is successfully using those criteria to his advantage, like how to advocate with lawyers or judges, for example.
Can I leave that question, because the last thing I want to talk about is the role for shelter workers. And so I'll make
Perfect.
sure to build that into my comments then. But thanks, Leah, and whoever asked that question. Okay, I'm going to look at a few cases here. And we've given you the link so you can find the case and read the whole thing if you're somebody like me who loves reading family court cases. This is a decision that was made fairly soon after the changes to the Divorce Act. And in it, it's an Ontario decision. The judge made note of the new provisions in the Divorce Act, in particular, the provisions that deal with family violence. And he said, and you don't have the full quote in front of you there, but I'll read it to you here. Flexible arrangements may not be appropriate for parents unable or unwilling to cooperate or communicate with each other. Detailed agreements or orders specifying the arrangements for the children may make it less likely that the children will be exposed to conflict between the parents. In cases of family violence, particularly spousal violence, it's crucial that the court consider whether a cooperative parenting arrangement is appropriate. A victim of family violence might be unable to co-parent due to the trauma they've experienced or ongoing fear of the perpetrator. In addition, cooperative parenting arrangements may lead to opportunities for further family violence. So this was a really positive case to see early on. The judge acknowledges that the law has changed and says, you know, that flexibility that can work in many families just doesn't work here. We may need detailed orders. We need to reduce the possibility of creating arenas for conflict. And in fact, the cooperative arrangement itself could lead to further family violence. And there have been a number of cases that have taken that kind of approach. The next case I'm going to talk about briefly took a very different approach. And, you know, people always ask me is, are you better with a woman judge or a man judge? I always say it doesn't make any difference. And here's an example, because Justice Benotto of the Ontario Court of Appeal is a woman. And this is a decision that's very troubling, especially for those of you who work in shelters. In this case, the mother took the kids to a women's shelter, saying she was afraid of the father and afraid that he might hurt her or the children. There was considerable evidence of verbal and emotional abuse by the father that was very specific to the woman's religious beliefs. The trial judge decided that both parents should have equal parenting time and decision-making authority, which is, you know, terrible. She rejected the bulk of the mother's evidence about the abuse. So the mother appealed, and she really didn't do any better there. Justice Benotto, writing on behalf of the Court of Appeal, dismissed the mother's appeal, noting among other things that the mother had, and I'm quoting here, and you can see some of this on your screen, unilaterally and wrongly removed the children from their home and kept them in a women's shelter thereby conditioning them to be fearful of their father. So please don't shoot the messenger here. I'm just reading what the judge said. She also supported the trial judge's determination that the mother's actions in seeking safety in a women's shelter had been a strategic move, quote, aimed at gaining a tactical advantage in the courts. So this is a terrible decision. This is a long time problem for sure. And I was very disappointed to see this kind of language in a decision made at the Court of Appeal level after the changes to the law. The third case I want to look at focuses on emotional abuse as a form of family violence, and also looks at how parenting time can be restricted to protect the best interests of the child. And if my slide would like to move, that would be great. The case involved a father who used parenting time as a way to maintain power and control over his former wife. He made highly derogatory and obscene comments about the mother to the children. He blatantly disregarded court orders and disrupted the mother's and kids' schedules by picking the kids up and returning them at random times. So here, the court found in favor of the mother's motion to vary the parenting order. The judge reasoned that if the court did not do so, the children would be subjected to ongoing and worsening instances of emotional abuse. The judge said it was not in the children's best interest for these kinds of behaviors to continue, that the father's ongoing denigration of both the mother and the grandfather in front of the children, that itself could be considered family violence under the Divorce Act. So a very liberal interpretation of that. In making his decision to vary the order, the judge noted that the new provisions in the Divorce Act regarding the best interests of the child, avoidance of conflict, and consideration of family violence must be considered. The recent amendments include a definition of family violence that goes beyond physical assault. It includes any conduct that is threatening or causes another family member to fear for their safety or their safety of another person, and that includes psychological abuse. So getting back on a good track here. There's a lot more cases. You will find some of them on the Luke's Place website. We post them there, and I encourage you to have a look at them. We don't have time to talk about any more than that today. I do, as my final few remarks, want to focus on what you folks can do. You're on the front lines. You're supporting women who are managing their abusive ex through the family court process. And of course, you're going to do the same things you do with these women as you do with any other woman. Believe them, provide them with emotional support, make referrals, and so on. But there are some specific family court related supports you can offer. You can assist the woman to get legal advice. So help her apply for a legal aid certificate if you live in a province where those are available. Keep a list of names of lawyers who you know have a good understanding of family violence. If you're in Ontario, you can refer women to the Luke's Place virtual legal clinic where they can meet with a lawyer over Zoom. It's completely confidential. They don't have to pay any money. There's no financial criteria. And my next point really speaks to the question that Leah posed a few minutes ago from one of you. It's all about evidence. The more detail the woman has about the history of abuse, the history of parenting, the needs of the children, the better positioned she is to offset any shenanigans on the part of the abuser. I'm not saying that this always works. Judges don't always pay attention to the things we want them to pay attention to, but keeping track of all kinds of details. Was he late to pick them up? Was he late to drop them off? Did he bring them back a day early? Did he keep them 2 days too long? What kind of communication happens while the children are with the father? Does he respond if there's an emergency with one of the kids, or does he not? Evidence, evidence, evidence. And another very important job is to assist the woman write out the story of abuse so that it fits with the best interest test. I'm going to come back to that in just a sec when I talk about a brand new resource that you can get through Luke's Place. Safety planning, obviously, is very important. Keeping on top of cases so you know how the courts are interpreting the changes to the legislation. And to assist with all of that, I want to talk to you about some new resources or a new resource and some older resources that we have at Luke's Place. This is a brand new resource. You can find it on our website, lukesplace.ca. And in it, there's a ton of really helpful stuff. But the one thing I want to mention in the context of today's webinar is that starting at page 24 is a checklist for the best interests of the child test that under each one of those factors that we talked about this afternoon are suggested questions for the woman to think about and space for her to write in what her answers to each of those questions would be. So she could download this whole toolkit. She could download just those pages. She could print them out. She can work with them online, whatever works best for her. A lot of other stuff in that toolkit that's really helpful, but that I think is spot on in terms of what we're talking about this afternoon. I would also encourage you to let your clients know about our family court survival workbook, which is called familycourtandbeyond.ca. You can download that as well. We've listed here where you can find case summaries. Really important to stay current with what the courts are deciding. And the summaries are written in normal human being language. So no problems with that. And then for those of you from Ontario, we've also included a link to information about our virtual legal clinic. So that's what I have to share with you this afternoon. I really hope it's been helpful. We're always happy to hear from people afterwards if you think any of our resources are helpful, or if there's a resource you'd like to see us develop that we haven't yet developed. So please check out our website and stay in touch. I'm not sure that we have time for more questions, and I don't see any there anyway.
No, so I mean, that works out well. But these are fantastic resources. That's wonderful that you have those available, and thanks for sharing them. And thanks for everything you've shared today. It's so helpful, so interesting. And so we will send out a copy of the recording and the presentations and those links that Pam has just shared that are in the presentation. So we'll make sure all of you have them. And so I just will wrap up saying thank you, Pam, once again for that wonderful, wonderful presentation. Thanks to all of you for participating, to the interpreter and Chandra for helping in the chat there. And I'll just remind everyone, we do have a feedback form that will appear when you leave the webinar, and I think Chandra will put it in the chat too. And it's always helpful if you have any thoughts to let us know so we can continue to improve. So with that, thanks again, Pam. Thank you so much.
Oh, my pleasure entirely. Hope to see all of you somewhere before too long.
Yes, definitely. And lots of thanks coming in the chat for you too, Pam. So
Great.
Thank you from
Thank
everyone.
you.
All right. Have a great rest of your day, everyone. And we will see you all soon.